2025. This is a special docket of the Oil Conservation Division. Today, we're hearing approximately 26 cases, including some contested cases. My name is Gregory Chikalian. I'm the hearing examiner. Today, we have various technical examiners, so I won't name them. So I'll start with the first case. This is case number 25480, Frontier Field. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Frontier Field Services, LLC.
Good morning. I don't think there's any other parties, are there?
There are not.
Okay, I've been advised by the technical examiners they've reviewed the amended exhibits and that the case is taken under advisement.
Great, thank you.
So thank you. Let's move on to Matador Production. This is 25250 and 25254. Entries, please. Do we have Paula Vance with us? Maybe we took Ms. Vance by surprise. Let's go on to Permian Resources. We'll come back to Matador. These are cases 25550, 51, 52, 53, 54, 55, 56, 57, 8, 9, 60, and 61. Entries, please.
Yes, Jackie McLean with Hardy McLean on behalf of Permian Resources.
Thank you.
And there are no other entries of appearance.
And are we here for amended exhibits?
No, this is the first time, and this will be very short because all of these cases are just asking for a 1-year extension of time to commence drilling the wells, so that they can obtain offset drilling results and determine optimal well spacing. So with that, I ask that the exhibits be taken under advisement and the exhibits be admitted into the record and the cases be taken under advisement.
Okay, thank you. The amended, well, no, not the amended. The exhibits are admitted without exception, and I'll turn to Mr. McClure, who I think is our technical examiner on these cases.
Yeah, Mr. Hearing Examiner, I don't have questions for the witnesses, but I would like to make a request from Ms. McLean for all of these cases.
Sure, go ahead.
If I can direct your attention to the last page of each of the exhibit packets with the notice of publication. It appears that for each of these exhibit packets, there was like scanned incorrectly or something where we're missing a sliver of the left clipping and then, a chunk of the right clipping. Do you see where I'm referring to?
Yes, and we had some serious difficulties with the Carlsbad Current Argus because the person that's in charge of the publications had a family emergency, and there was a lot of problems with these publications, and this was the best that they could put together for us. I'm not sure if we could maybe get a copy of the newspaper or something and add it on there, but I think we're stuck with this affidavit, unfortunately.
I guess if maybe we get a supplemental exhibit with a complete scan of the clippings, I guess, and then just yourself saying that it is the same clipping, I guess. If you understand what I'm saying?
Yes, I can just add a paragraph into the affidavit that I submit saying that I've reviewed the publication and it's the same as what is attested to in the Carlsbad Current Argus's affidavit.
Mr. Hearing Examiner, do you think a statement from the attorney should be sufficient to take that into the record, or what is your thoughts on that?
So, I'm looking at the last page right now myself, and I think you said that the that the right column is cut off. I see that. And then you said, was there something else that was cut off, or was that it?
Yeah, well, in the middle of the page, the left clipping, it has a sliver that's missing off of it, where kind of the bottom half of it is missing like a word on the right-hand
Okay.
side.
Okay. So Ms. McLean, is it possible does this appear online as well?
The affidavit of publication?
No, not the affidavit, the actual publication. I don't think
Yeah.
it's the app.
Yes, you can access it online.
I thought so. So are you able to, so the affidavit is complete?
Yes, the affidavit is complete. It's just the copy.
Right.
Because it was so long, and because it was done,
Yeah.
not,
Okay.
not by the person who usually does it. But I mean, you can easily access it online.
You can, okay.
And we had done so to make sure that it did get published, because we did have a question about that.
Okay,
at one
good. So
point.
you did. You're saying that for all of these cases, you reviewed the publication and you find it complete?
Yes, that's
Okay,
correct.
all right. I think for me, Mr. McClure, for me, that's good enough to have the attorney state on the record that this notice is complete. Now, are you able to print it from the internet and submit it as a supplemental exhibit?
And I could try, or take a screenshot or something.
Or something? Would that be good enough for you, Mr. McClure?
Yes, it would be, Mr.
All right.
Examiner.
So, Ms. McLean, I know you're in hearing today, so why don't we leave the record open in these cases? We don't need to come back on the record to receive the supplement from you. If you'll just file the screenshot or whatever of the actual notice in these cases as a supplement, maybe with a little paragraph saying that, you attest to the completeness of them as well, that'll be good enough for me, and we can take these cases under advisement.
Okay, thank you.
All right, thank you. So that means the record will remain open till 5 o'clock tomorrow afternoon. Okay.
Mr. Hearing
Yes, Mr.
Examiner.
McClure. Yes.
These are also the cases that I don't know what our thoughts were in regards to pre-hearing statements for them.
So that's a good question. So thank you, Mr. McClure. Ms. McLean, why were there no pre-hearing statements submitted for these cases?
There definitely were.
Oh, there were.
I mean, I submitted them myself.
Okay. All right. So Ms. Chance looked and she didn't have anything in the queue.
It's weird. Let me look.
And we can come back to these cases if you want to take a few minutes and look. I'll call those other cases that I called earlier, the Matador cases for Ms. Vance.
Okay.
There we are. There's Ms. Vance.
Sorry,
And
I was having technical issues.
Not a problem, Ms. Vance. You want to enter an appearance on 252, 50, and 54?
Yes, thank you. Good morning, Mr. Hearing Examiner, Technical Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage, appearing on behalf of Alpha Energy Partners, and we are just making an appearance and monitoring at this point.
Perfect. Thank you, Mr. Savage. Do we have anyone from ConocoPhillips or from Mewborn?
Mr. Examiner, Jim Bruce representing Mewborn.
Okay, thank you. And your position, please?
No objection to the case proceeding by affidavit.
Good morning, Mr. Examiner. Beth Ryan on behalf of ConocoPhillips and Marathon Oil Permian, and we are not objecting to these applications today.
Okay, perfect. Thank you, Mr. Ryan and Mr. Bruce. Ms. Vance?
Yes. So we're just here to, because we made a correction to the compulsory pooling checklist per Mr. McClure's request, that the line item for the primary product to be listed as gas. And so we did that and refiled amended hearing packets.
Okay, so your hearing packets are admitted without exception. Mr. McClure, satisfactory at this point?
Yes, Mr. Hearing Examiner.
Thank you. We'll take these two cases under advisement. Let's return now to Ms. McLean.
Thank you.
Thank you. Ms. McLean, any idea what happened to the pre-hearing statements? Hmm. You want to take
It shows that I filed it at 3:30 PM. So I don't know.
a 3:30 PM what day? We can come back. If you're not ready for a complete answer, we can come back.
Well, it's making.
You want a few more minutes?
Yes, because I just don't know how I can see exactly how, other than I submitted them and then I don't, then it kind of goes into the ether sphere.
Maybe Ms. Chance, what day did you submit them?
It would be the same, I submitted them at the exact same time as that exhibit.
Okay. So what day is that? Okay. So Ms. Chance, are you able to look and see if they were rejected?
I'm looking now. I do recall seeing something weird,
Deborah.
some type of glitch. So
But I know for sure I filed everything because it wasn't the typical day, so they were getting for today. So Thursday.
I understand. I guess the concern that the technical examiner and I have is that there's no pre-hearing statement. We really can't hear the case properly. It has to be submitted. So we have here the 16th. Freya, do we have another docket coming up later on September?
we have September 30th.
On the 30th. So if you filed those pre-hearing statements today and then you got a supplemental exhibits, not that that's holding up the case for the publication, we would foot the bill and continue them to the 30th, but I don't see how we can hear them today without pre-hearing statements.
There's no other.
It's the rule. My concern is that the rule says that you have to do something a certain number of days before the hearing, and that hasn't been done. And I'm not saying it's your fault, it just hasn't been done.
Yeah.
Hmm. Right.
And I don't know why. We reject.
It's the only avenue I can see to have these move forward in an expedited way without waiting till October 9. If we had another docket between now and then,
Is I believe there's one on the
right, that's what I'm saying. And then we can put them on there. We'll put them on there ourselves, so you don't have to pay for that. I mean, it's not your fault it happened.
Okay, that's fine.
It's fine. Okay. Freya, would you move these amendment cases to the September 30th docket?
Yes.
All right, thank you. So, Mr. McClure, thanks for bringing that up. Yeah, right. All right. Okay, we're off the record in the amendment cases for Permian Resources. They're coming back on September 30 to cure the pre-hearing statement issue and the notice publication cutoff issue. Let's go on to Longfellow Energy 25572. Entries, please.
Sharon Shaheen on behalf of Longfellow Energy.
I don't believe there's any other parties.
To my knowledge, no other party has entered an appearance.
Great, go right ahead.
Thank you. In this matter, Longfellow seeks to pool the south half of Section 31, Township 16 South, Range 31 East in Eddy County, New Mexico, to dedicate the following wells: the Petty Federal Com 31 CD 006H well. I believe that's, oh, and then the 2H well as well, and the 3H well, and the 4H well, and the 5H well, and the 6H well, and the 7H well, the 8H, the 9H. We have the usual exhibits. Our landman, Mr. Stuart Gaston, has not previously testified before the division, but he should be available to be qualified as an expert witness. Likewise, our geologist, Mr. Jake DeHammer, is also online to be qualified as an expert witness. We have the usual exhibits. Exhibit A is Mr. Gaston's statement with the usual sub-exhibits. Exhibit B is Mr. DeHammer's statement with the usual sub-exhibits. And my statement notice is attached as Exhibit C. Notice was sent out by letter to all interested parties August 21st, and the affidavit of publication indicates that it was published on August 26th, 2025. I'm happy to answer any other questions, and we'll move for admission of the exhibits and ask that the case be taken under advisement after my witnesses are qualified.
Sounds good. Thank you. Question on your notice. Did you take into consideration the holiday on September 1st?
We did. My assistant calendared it that way.
Perfect. Thank you. Okay. Your exhibits are admitted without exception. Let's get the two witnesses on the screen. I see one person on the screen. I'm not sure. That's Mr. Stewart Gaston. Mr. Gaston. I see Mr. Jacob DeHammer. Excellent. Would you please both raise your right hands? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
All right. Let's start with Mr. Gaston. You can put your hand down, Mr. DeHammer. Would you spell your name for the record?
Yes, sir. It is Stuart, Stuart, Gaston, Gaston.
Thank you. And you're seeking to be qualified as an expert in what field?
In land.
Land, very good. Have you been qualified as an expert in land matters before other tribunals?
No, sir.
Okay, very good. Why don't you give me a little bit about your education and your work experience? Give me dates when you talk about those, and try to be a little specific about your responsibilities when it comes to your experience, your work title, and that sort of thing. So go ahead.
Yes, sir. Thank you. I began my work in oil and gas in 2013, May 2013, working for a company named Big Star Oil and Gas in Midland, Texas, primarily focused in Howard County. I had worked at Big Star for approximately 3 years before the company was sold to Callon Petroleum. I then switched over to Callon Petroleum in around 2016.
Can I stop you for a moment? So when you so first, let me hear about your education. So what degree and from where, if you would start?
Yes, sir. So I graduated from Texas Tech University in 2012 with an undergraduate degree in business management. And after some time, I went back to school and was admitted to the Working Professionals program at Texas Tech. And in 2017, achieved my Master's of Business Administration.
All right, excellent. So when you were working for that first company, I think you said it was called Big Star. What was your responsibility there?
Yes, sir. So primarily in-house land work. So everything from title examination to leasing to forming units, drill prep, drill curative, kind of small shop operator. So kind of do everything.
And then the next employer was who?
Callan Petroleum in Midland, Texas. So at Callan, a little bit bigger company. Yeah, primarily did the exact same thing, just on a little bit bigger scale. It worked the same asset, and with some foray into Midland County and a little due diligence program in Delaware.
And what were your responsible, what were the dates you worked there?
From 2016 to 2019.
Okay, and then who?
After
Yes.
Callan was a company called Silver Creek Oil and Gas in Dallas, and worked there for approximately 6 months. The primary focus there was kind of the same in-house land stuff, just in different counties.
Okay. And now with Longfellow, what is your title?
My title is Senior Landman.
Okay, that's good enough for me. You are recognized as an expert in petroleum land matters before this division. Now let's go to Mr. DeHammer. You heard what we went through. Would you go through the same? But you have to unmute yourself or else I can't qualify you.
You're right. My name is Jacob DeHammer. Would you like me to spell it?
Yes, please.
Jacob, DE capital HAMER.
Okay. And what field do you seek to be recognized as an expert?
Geology.
Your education?
I graduated from Kelvin College in 2006 with a Bachelor of Science in Geology, and from there went to Louisiana State University, where I graduated with a master's degree in Applied Geology in 2010. I've worked in the oil and gas industry for various operators for close to 18 years, I guess 17 years. And I've been with Longfellow since 2022 in the geology department, working New Mexico and West Texas.
So what's your response, instead of going through all of it, what's your responsibilities at Longfellow?
At Longfellow, I'm responsible for the geology side of our New Mexico operations, exploration, acquisitions, and development, as well as other lower 48 projects that we have going on.
Okay, and how long have you been with Longfellow?
Since May of 2022.
I see. And what's your title there?
Senior geologist.
Okay, perfect. So you're qualified before this division as a petroleum geologist. Mr. McClure, any questions for the two witnesses?
Mr. Hearing Examiner, I do have a quick topic to ask the landman about.
Okay, Mr. Gaston,
Yes, sir.
you're under oath. So Mr. McClure, go right ahead.
Okay, thank you, Mr. Hearing Examiner. Mr. Gaston, if I can draw your attention to your summary of ownership. I believe that's in your exhibit A-3, page 40 of 135.
Sorry, bear with me, sir.
I'm going to
Yeah,
share
take your
here
time.
Oh,
in a moment.
thank you, Sharon.
And Mr. Gaston, do you see what Ms. Shaheen is sharing with us?
Yes, sir, I do.
Can you describe very briefly what the nature is of the non-executive working interest owners on this table?
A little bit of a doozy here. A non-executive working interest owner, in this case, there was some leasehold interest that was owned by a single company who had conveyed out in a certain deed portions of this leasehold interest, but retained the executive rights under that leasehold, which truthfully, sir, I hadn't seen before, but this was a case that we looked at and said, hey, how do we treat this like it should be treated? Closest thing we could approximate it to was maybe non-executive mineral ownership, where they are subject to another individual's executive rights, whatever they decide to do with the leasehold interest. These parties that are subject to that single executive right owner are bound to their decision. Similar to like kind of a remainderment. So in a life estate or a similar situation of that nature.
So then there's some sort of agreement in place in which working interests transferred to these different persons, but control of the working interest was retained by the original owner. Is that correct?
That's how they styled the assignment out of them. Yes, sir.
Okay. So who is the executive working interest owner then?
Of those
this
parties,
interest?
yes, sir. Of those parties, it would be TIG Properties.
Okay, which Longfellow is requesting the division to force pool in this case.
Yes, sir.
So then is Longfellow asking the division to force pool those other interest owners as a part of that agreement then? Because they're the actual working interest owners?
Well, they would be subject to TIG Properties election to either participate or not participate, or their election under the forced pooling. To the same extent, TIG Properties may be, required to at least inform their non-executive parties of the forced pooling as well.
So then whatever happens to TIG happens to all of these persons then, is that correct?
Yes, sir. That would be my understanding of the situation.
Okay. I have no further questions. However, I would like to draw Ms. Shaheen's attention to your notice letter, Ms. Shaheen, on page 83 of 135. Do you notice your website that you have listed there?
Yes. Is that incorrect?
Yes, can you please make a point to go into your templates and correct that to the website that has been in place for 2 or 3 years plus now?
Absolutely. Thank you for that.
Okay, thank you. Thank you, Mr. Hearing Examiner. I have no further questions or requests for this case.
Thank you, Mr. McClure. So we'll take this case under advisement.
Thank you.
Let's move on to Mewburn Oil. These are Mr. Bruce's cases, 255-73-7475.
Yes, Mr. Examiner, can you hear me?
Yes.
Okay. My phone shuts off or involuntarily terminates the mute or institutes the mute clause on me, so I'm never sure. Yes, in this matter, I've submitted an exhibit package, and I'll have a couple of comments at the end. But in this matter, Mewburn seeks to force pool the south half of Section 9 and south half of Section 8, 22 south, 27 east, for purposes of drilling the Sandlot Fee 527H well, which is a second Bone Spring sand, and the Sandlot Fee 557H well, which is a third Bone Spring carbonate well. I would note that the 557H well is unorthodox and Newbern is applying administratively for approval of that location.
Mr. Bruce,
Yes, sir.
if I could interrupt you just for a second. Mr.
Sure.
Hearing Examiner,
Yes.
unfortunately, these 3 newborn cases are ones that I did not have time to review the exhibits for.
Okay.
So I don't know if you wanted Mr. Bruce to continue or what your thoughts was, I guess.
Okay. Mr. Bruce, not due to any situation that you brought on, we'll have to move these cases to the September 30th docket and hear them by affidavit at that time after they've been reviewed.
Okay.
I apologize, Mr. Bruce. I just didn't have a chance for these ones.
Well, and Mr. McClure, I was going to brag that at least on this one, I actually got a expandable cross section for you. But, you know, small accomplishments. Okay, and the second thing I was going to say is the exhibits had to be revised anyway, because I did not receive any green cards or affidavits of publication until last Thursday. So I need to revise this accordingly. And so you will be seeing a different color exhibit package, Mr. McClure. So you can probably deep six what you have, but I would ask, since it's continued, do I need to file continuance motions, Mr. Examiner?
The answer would have been no, except that obviously you need to add evidence to the packet, but I'll still, because really we did not review them by our own admission. Ms. Chance, will you move these 3?
Yes.
To September 30th, no cost to Mr.
Yes.
Bruce. All right. Okay, Mr. Bruce, we'll see you on the 30th. We'll put these toward the top of our docket.
Thank you, Mr. Examiner.
All right. Thank you. We're off the record in these cases. Let's now move on to our contested case. This is Marathon Oil versus Tumbler. I'm going to call the case numbers. This is 2554142. 254, 62, 63, 64, 65, and 66. Answers of appearance, please.
Good morning, Sharon Shaheen on behalf of Tumbler Operating.
Good morning, Dana Hardy with Hardy McLean on behalf of Marathon Oil Permian LLC.
Thank you.
Good morning, Mr. Examiner Matthias Sayer on behalf of EOG Resources.
Thank you. Mr. Sayer, what's your position?
We have no position. We're just monitoring. Thank you, sir.
Perfect. Thank you. Okay. All right. It's my understanding that there were some last minute exhibits filed. Is that by you, Ms. Hardy, or me, or you, Ms. Sheen?
Mr. Examiner, we filed rebuttal exhibits last evening, and I just, after this hearing was scheduled to start, received some from Ms. Shaheen.
So both parties have filed rebuttal exhibits.
Yes.
That is correct.
All right. Sounds good.
And we had also filed a motion to exclude certain of their exhibits.
Okay, perfect. So why don't we hear that as a preliminary matter when we get to it? Well, let me just clear up some other things first. Ms. Hardy, I know that there were some amended applications filed in your 2 cases, and that you indicated Ms. Shaheen's position was that she didn't oppose your filing them. That's what I saw in the. Did you not put that?
I don't recall that. I mean, the amended applications were filed before they were noticed. So
Let me pull it up. I know what I saw, but I'll pull it up again anyway. Give me 1 minute. What is your case number? Is 25541. Shaheen, do you not remember this?
I vaguely remember that amended applications were filed. I don't recall a discussion about them. And
Okay. Maybe I read something incorrectly, but let me look. Could have sworn that's what I saw. All right, 25541. Let's look at 5541. And here's the case file. And let's look at the amended application. What date did you file? There's no titles to any documents here.
August 6th.
Thank you. August 6th. This is in 25541,
Yes.
August 6th. I don't have any
So-
documents going back that far. The most recent document I have is 814. Could that possibly, yes, that's a pre-hearing order, a motion to amend.
We did file a motion to amend the pre-hearing order, but I'm looking at the case file and our amended application filed August 6th of 2025 is posted.
On what date did it post?
August 6th of 2025.
Maybe something's wrong with the system because I don't
Could
see it
be.
at all. I start out with the first document on 814. I know it's impossible because you must have filed something before that.
So I see that.
You do see that, okay.
but-
Mr. McClure is helping me in the background. So here we have, as always, he's always helping me. Thank you, Mr. McClure. The amended application shows up on the 22nd. I don't know why. Not that you filed it on the 22nd, but in the imaging system. And it says here at the end of your well, maybe you didn't. Maybe this is not what you asked Ms. Shaheen, her position. So, okay. Why did you file an amended application?
So we corrected the well numbers. There were changes in the well numbers because the original numbers had been the ones assigned by Marathon prior to the acquisition. And so we updated the well numbers and the names. And then I think a couple of the wells changed locations. I don't remember exactly, but we did this. We filed these amended applications before the original applications were even noticed. So we had them basically swapped out to replace the original ones. And so these were the applications that were noticed to the parties and publicly noticed, including to Tumblr, 30 days before the September docket, which would be the initial docket that they would have been set on.
That makes total sense, what you said. I think there was another change made. If you look at line 4 of your amended application, it says range 34 east. On the original application, it said 24 east. That's what was noticed today. You don't remember changing that 34?
I don't recall that.
Okay. Well, anyway, so we'll probably have to renotice at least one case. Mr. McClure, how many cases are affected by the 24 to 34 change?
I believe our notice might have the 24 for both cases.
Right.
I know the public notice is incorrect for 25541, but it seems to be correct for 25542.
Perfect. So it affected that range error affected public notice that you published in one case, 41. So that'll have to be redone. And it also affected our notice because we must have grabbed the original application legal description, and put it in our public notice that we post. So we'll have to post new notice for both cases. But that's fine because we'll have other amendments and other requests for the parties at the end of this contested hearing anyway. But we'll have to notice it at least 20 days down the road, as you know, and you'll have to publish new notice for one case at least. That's your decision to look at them and decide what's best for your client. I'm not telling you what to do.
Okay.
But I am saying that what we need to do is notice them properly. Okay?
Okay.
So we will end up coming back on the record in at least 20 days, maybe a few more days, depending on what the parties need for their exhibits. Okay? All right. So I wanted to bring that up early on. Now, Ms. Shaheen, you filed the original Tumblr applications. They predated the marathon cases. Are you prepared to go first?
Yes,
Okay.
we have conferred
Oh, good.
and Tumblr has agreed to go first.
Perfect.
That said, I would like to talk about how we do this. I always feel like it's a little convoluted with us going first and then trying to do rebuttal at the same time. So what I would propose is that Tumblr goes first, summarizing its direct testimony, standing for cross, and we also do redirect. And then Marathon would then do the same and present its rebuttal. And then Tumblr would come back to present its rebuttal. And then Marathon would have an opportunity for redirect. To me, that makes
it's
the
a
most.
logical suggestion, but what we have done in the past that seems to have worked, and I think it's a little bit more, it's easier on the witnesses instead of having them come back for rebuttal, is just to do the whole thing. Each witness presents its direct and rebuttal testimony in summary fashion, stands for cross, redirect, et cetera, and that way witnesses who may want to fly out this evening and maybe the rebuttal wouldn't come till tomorrow, depending on how long things take, then at least they're relieved of that extra burden.
I understand that. And I think that works fine so long as we have the opportunity to do additional rebuttal depending on what Marathon's witnesses say.
You'll have a full and fair opportunity to present your cases without question. That's my job.
Thank you.
Ms. Hardy, anything on that?
I agree with our normal process, which is what you just outlined. Thank you.
Right, you've been through it before, right? Exactly. Okay, so then Tumblr is going to go first. How many witnesses do you have?
4.
You have 4 witnesses. Okay. Would you tell me their names now?
The first is our landman, Nicholas Weeks.
Weeks?
Yes, Weeks.
Okay, yeah, we'll get them to spell. I'm just trying to write it down phonetically. So that's your landman. Okay.
The second is our geologist, Dylan Collins.
Collins. Okay.
The third is our engineer on petroleum engineer discussing operations and facilities, and that is Walt Baker.
Baker. And last?
Finally, we have Chris Villarreal, who I will also refer to as Mr. V for convenience. He's also a petroleum engineer, but his primary expertise in this matter is planning and development.
Have all 4 been previously qualified before this division?
No, only Mr. Weeks.
All right, so we have Mr. Weeks is qualified. The other 3 need to be qualified. Okay. So you've submitted original exhibits and rebuttal exhibits.
That is correct.
Okay, and you've labeled them as such?
I believe so.
So the rebuttal exhibits, are they in line with the original exhibits, or are they separate and they're called the rebuttal exhibits?
They're separately called rebuttal exhibits, but what I believe we did is consecutively identified them as an exhibit. For example, the landman rebuttal exhibit would be A7.
Okay, but it would say rebuttal A7.
I hope so. That's what I hope my assistant did this morning. I didn't have a chance
That's
to
fine.
review it.
If not that, I want to be very clear about what's rebuttal. There is an objection to some of the exhibits, so we'll need to deal with that objection early on. But I wanted to know that they were separately identified. Okay. Okay. Now, so typically what we do is for anything that is admitted into evidence, we just have a summary by the witness. Generally, about 15 minutes has been more than enough for a witness to summarize. If it's not been admitted, and if you have to provide foundation, then it might take a little time because there's a voir dire process that the other party can, challenge your foundation, let's say. Okay. All right. Is there anything else? Are there any other preliminary matters that you want to bring up before I go to Ms. Hall?
Not that come to mind.
Okay. Ms. Hardy, okay. Okay, Ms. Hardy.
Thank you, Mr. Examiner. Would you like me to introduce our witnesses or tell you who they are? Is that the, okay,
Let's start with your witness.
sure. So our witnesses are landman Sean Miller.
Hold on. Has he been qualified?
He has.
Perfect. Next,
And geologist Tyler Patrick.
Patrick. Has he been qualified?
Yes, he has.
All right, very good. And those are your only two witnesses?
They are.
Okay, very good. If I'm not mistaken, and it may be a short opening when it's your turn. So Machine, just plan on a brief opening, like a 1 to 2 minute opening to explain your case, what you think the evidence will show. That's all I want to hear. Not argument, just what you think the evidence will show and why we should grant you approval of your applications. Ms. Hardy, as part of your opening, I'd like to understand what happened to Marathon's original compulsory pooling orders that seem to have been amended once and then evaporated, or whatever you want to call it.
Sure.
Okay, so we have two witnesses. You have exhibits that you filed along with a pre-hearing statement timely. And then your rebuttal exhibits, are they marked as rebuttal exhibits?
They are.
All right, excellent. Ms. Shaheen, have you had a chance to review Ms. Hardy's exhibits and rebuttal exhibits?
I have reviewed her exhibits. I have not reviewed the rebuttal exhibits, but my client has.
Oh.
And I will be relying on my client with respect to the rebuttal exhibits today, if that's acceptable.
Okay.
So I don't forget any.
Excellent. So as a preliminary matter, do you stipulate to any of the exhibits coming in as evidence?
You're asking me with respect to all of Marathon's exhibits?
Yes.
There's a caveat to that, and I think it relates to our motion to Ms. Hardy's motion to exclude our exhibits. With respect to their rebuttal exhibits, I did look at them briefly, and my take on them is that they should have been presented in the direct case. They are not actually true rebuttal exhibits.
So that's fine. So you object to the rebuttal exhibits. Do you stipulate to the original exhibits?
I stipulate to their admission.
Perfect. So Ms. Hardy, your exhibits are admitted into evidence, except the rebuttal. And so Mr. Court Reporter, please keep track of the exhibits. All right, very good. So Ms. Hardy, give me, is it A, B, C, D? What do you have for exhibits? I'm not looking at it right now.
For our exhibits,
Yes.
our original exhibits, we have Exhibit A, which is a self-affirmed statement of Sean Miller, and his sub-exhibits A1 through A11.
Okay, so those are admitted into evidence.
Thank you. And for our geologist, Tyler Patrick, we have Exhibit B and sub-exhibits B1 through B4.
So those are the exhibits that are admitted to evidence through stipulation by a machine. All right.
And then we have our notice exhibits. We have Exhibit C and sub-exhibits C1 through C7.
Okay, very good. So those are admitted into evidence as well through stipulation. How are your rebuttal exhibits labeled?
They are labeled sequentially. Let me pull them up.
I think
We
Ms.
have-
Chance is just admitting them now into the imaging system.
We have Exhibit A12,
Okay.
which is Mr. Miller's rebuttal exhibit.
Okay.
And then we have exhibits B5 through B7,
Okay.
which are three rebuttal exhibits that Mr. Patrick will address.
So we have 4 exhibits that are not yet admitted into evidence that you'll have to provide foundation for unless we get a subsequent stipulation down the road.
Sure.
Okay. Now, same question to you, Ms. Hardy, for Ms. Shaheen's exhibits. Which ones do you stipulate to?
Let me pull them up. I mean, I know what we object to.
Let's start on a positive. Let's start on a positive note. Which ones do you stipulate to?
Okay. Okay, exhibit A2, A3, A4, and I believe A5. Exhibit B and B1 through B5.
Okay.
Exhibit C and C1 through C4. And then I do not stipulate to exhibit D or D1 through D14.
Are those the rebuttal exhibits?
No, those are Mr. Villarreal's exhibits.
Who?
Mr. V.
Oh,
Mr. Villarreal.
Mr. Villarreal?
Yes.
Isn't that how you say it?
However you want. B works.
Okay, we're gonna say Villarreal. So you're not, okay, so I want to make sure the court reporter caught, yes. Okay, so you got the A, Bs, and Cs, but the Ds, even though they're not rebuttal, you don't stipulate to.
Correct.
Okay, perfect. And then what about the rebuttals? Which ones are you objecting to now?
I just received them moments ago.
Yes.
And I think I'm objecting to all of them.
What are they labeled is the question.
They are exhibits, Tumblr exhibits A7, A8, B6, B7, B8, C5, and D15.
I see how you did it. So you basically added on to your original exhibit numbers as the rebuttal exhibits.
That's
I understand. Okay, so those are the objected ones. So
May I just clarify with
Yes.
Ms. Hardy? Because my understanding was the only objection to Exhibit D was paragraph 7, and that the rest of Exhibit D was not objected to. So that would be my only clarification with the list that Ms. Hardy gave you.
Well, paragraph 7 is 4 pages of the affidavit. So I'm going to not stipulate to any of it. And we have objections to several of his sub exhibits, and some of those there are certain ones we've addressed in our objection, and then the others I will not stipulate to. I can't
all right.
either.
Okay, is the basis foundation of your objection, or I mean loosely qualified? Is it foundation, or what is it?
The exhibits and the testimony include there are a lot of reasons for the objection. They include false statements.
Okay.
They lack foundation. They're speculative, and they're irrelevant and beyond the witness's expertise.
Fine, that's a good list. All right, thank you. All right, so we've admitted through stipulation certain exhibits from Tumblr by Ms. Hardy. Now we have a motion to exclude. Now, does your motion to exclude exhibits, which exhibits specifically does the motion relate to?
The motion specifically relates to exhibit D, D3, D4, D5, and D9. And then in exhibit A, Mr. Weeks' affidavit, we object to paragraph 28 of exhibit A, which is his affidavit, and then exhibit A1, which are the C102s.
So I'm a little confused by the list you just gave me, because it sounds like we've admitted the A exhibits.
No, I agreed to admit A2 through 5.
Okay.
But exhibit A, we have that objection to, at least to the one paragraph.
Let me start a new page here.
Okay.
All right, so hold on a second here. So, Ms. Shaheen, you objected to the rebuttal exhibits only from Marathon.
That is correct.
Very good. I'm just going to write this down. Okay, Ms. Hardy, specifically, I'm sorry, you're going to have to go through this list again for me. Which A exhibits are you only want to know which A exhibits you're objecting to?
Exhibit A,
A itself,
yes,
okay,
and A1,
and A1.
yes.
All the other A's except the rebuttal exhibit A, which is what? What is the rebuttal exhibit A? But
Their rebuttal exhibits,
just the A.
it's A7 and A8.
All right, so here's what I understand from you. You're objecting to A, A1, A7, and A8. The
Yes,
other A's all are in evidence.
yes,
Perfect. Can you give me the B's? Objecting to.
yes. We do not object to the Bs.
What about the rebuttal B?
The rebuttal B, I do object to.
Right, so what number is that one?
B6, B7, and B8.
All right, hold on. B7 and B8. Okay.
And B6. Did you get?
B6, 7, and 8.
Yes.
Got it. And any C's? Are you objecting to any C's?
We object to rebuttal exhibit C5.
Yes.
And then otherwise, no.
Okay, and then the D's?
The Ds are where
All
we
of
have the real problems. Yes.
The D's, all of the D's. So so it's D and then D1 through what?
15.
Okay, and that includes the rebuttal.
Correct.
Perfect. Okay, now your motion was not to all of these because you hadn't seen the rebuttal exhibits when you filed your motion, right?
Right.
Okay, so what is the basis of your motion?
Would you like to hear?
Yes.
I can give you my presentation on the
Yes,
motion.
please, yes.
Okay. I want to start by saying that in evaluating competing development plans, the division is engaging in a serious technical fact-finding process that impacts not only the operators appearing before it, but the state of New Mexico. And as we all know, the taxes and revenues from oil and gas development are considerable for the state. And this is a forum for serious scientific and technical evidence presented under oath, just as it would be in a court of law. It's not a forum for marketing presentations, hyperbole, and emojis. And unfortunately, Tumblr's witnesses, particularly Mr. Villarreal, seem to lack regard for this process. The first basis for exclusion, and I can actually pull this up and show it, are really the statements in Mr. Villarreal's testimony and exhibits that are essentially false. He has altered quotations that he attributes to Marathon in his sworn testimony and exhibits to materially change their meaning, and he's done it more than once. He is arguing that Marathon does not actually intend to develop these units. And in support of that argument, on page 8 of his testimony, which is page 218 of their PDF, he has a quotation stating, quote, "The Goliath unit won't be developed," end quote. And he attributes that quotation to Marathon. He doesn't provide a citation for it, but he's attributing it to Marathon. And when you look at his exhibit D5, which is page 229 of the PDF, you can see from the quote, he's quoting Miss Caroline Frederick at Marathon. She actually states the Goliath unit won't be developed in 2025. So he revised the quotation to delete a material part of it that's important to this case. And this wasn't inadvertent because he's done it multiple times. He does it again. I can share my screen because I think it's helpful for the commission to see it, the division to see it. So when you look here on page 229 of his PDF, he states here, and this is one of the exhibits we've moved to strike, He is attributing a quote to Mr. Sean Miller, who is one of our witnesses who you will hear from, in a March 31st, 2025 email. And he states, an understanding of that situation and the fact we have such a large portfolio of New Mexico inventory competing for capital is needed to explain why COP is not developing the project, period, end quote. He's using that to argue that ConocoPhillips is not going to develop these projects. And he is saying that that is a quotation. And I have the email here. When you pull up the actual email from Mr. Miller, it states, an understanding of that situation and the fact we have such a large portfolio of New Mexico inventory competing for capital is needed to explain why COP is not developing the project this year. So Mr. Villarreal is altering quotations in his sworn testimony and exhibits. Okay. So that's a reason that I think it's all unreliable and needs to be excluded.
So my, and Ms. Shaheen, I would come to you, but what I'm proposing to Ms. Hardy is this. Unlike a motion to suppress before a trial where you are trying to exclude evidence that is obtained in an unconstitutional fashion, here in this administrative process, it seems to me another way of doing this, and your motion's out there. But what I'd like to do is you're showing me information that I think could be done during a voir dire of a witness. So I understand why you have objected to the exhibits, that you find them factually incorrect, and that's, of course, a good reason to object to them. But instead of going further with the motion, unless there's some other basis that is so procedurally unsound that it allows me to say, I'm not going to accept these exhibits because whatever that reason would be, why not, when the witness is on the witness stand, asked to voir dire the witness, then you can show me this information. You could have, you could call one of your witnesses to testify and say that's not whatever, however you want to do it. It'll also give Ms. Shaheen an opportunity to question her witness and bring out maybe an alternative viewpoint. I don't know, but there it is. So that's the way I would proceed. I would suggest proceeding. How do you feel about that?
Well, Mr. Examiner, I understand that we do have other reasons for the exclusions.
You do? Okay, what are they?
I think that Mr. Weeks and Mr. Villarreal include speculative information that they really don't have any evidentiary basis for, and also their qualifications. It's outside the scope of their expertise. And I think that that is important to the division in evaluating evidence. Mr. Villarreal talks about ConocoPhillips corporate reorganization, capital spending. He has a number of speculative statements about how he thinks that may impact New Mexico. It's really not in his expertise as an engineer to be opining on corporate matters like that. And the information is also irrelevant and is going to waste time to go through it. For example, he has slides on ConocoPhillips consultant, making corporate recommendations, on corporate reorganization. There's no information anywhere in the record that any of this has an impact on these wells that are proposed to be drilled in Lee County, New Mexico by Marathon and ConocoPhillips. So it's a waste of time and it's irrelevant.
So Ms. Hardy, I could understand if you're trying to exclude him as a witness altogether. But if that's not the case, and we're going to have Mr. Villarreal testify at some point during this proceeding, I would think that at that point, before, I mean, nothing's been admitted. There's nothing. You could at that point voir dire the witness and then bring out the concerns for each of these. Let Ms. Shaheen deal with those, see how I rule on those, and go forward. But I understand the basis. Does that sound like a good way forward?
Yes, that would be acceptable.
I mean, because it doesn't sound like something I could rule on at this moment here with finality. I think it's better to hear from the witness, hear from you, hear from Ms. Shaheen, and then make a determination for each of the concerns you have. Is
Understood.
that okay?
Yes.
All right. Ms. Shaheen, did you have anything that you wanted to say?
Well, I had 5 pages of argument, single space, that may not be necessary in light of how you're handling this. I would just briefly say that we're entitled to full and fair presentation of our case. I'm ready to address all of the criticisms that Ms. Hardy has made. I believe that the testimony and the exhibits go to weight and not admissibility, especially because we're in an administrative proceeding.
Thank you. So let me just remind both parties how I view the rules of evidence, because ultimately you're really talking about the rules of evidence here, as is, I think, um, uh, there has been quite a long history of applying the rules of evidence in a relaxed fashion in the administrative forum. They can be used as reference, but and I'll consider all arguments, and I do all the time. But the rules that I use the most are whether something is relevant and whether something is reliable. So when it comes to relevance and reliability, some of Ms. Hardy's arguments do touch on relevance and reliability. And if she can show me that this witness, let's say, is talking outside of his field of experience, then of course it becomes so unreliable that unless it's lay witness opinion and is somehow qualified under lay witness opinion, then it would be outside the expertise of the witness. We do have to qualify your witnesses. So this would be a good point, Ms. Hardy. We're going to be qualifying witnesses. It would be a very good point for you to bring out as much as you want me to understand about their expertise. And then later, when they're testifying about their exhibits and on the witness stand, we can then go into each exhibit where you feel it may go outside. And Ms. Shaheen can make arguments, obviously, about how it's not outside and how it really only is the weight of the exhibits. But good points. They're all good points. I would like to take a 5-minute break before we begin. And I think what we'll do is, if you'll have your witnesses come up to the witness stand, we'll get them sworn in. Yes, as a group. We'll get them sworn in, and then we'll go through their expertise. And then at that point, Ms. Hardy will have an ample opportunity. So let's take a 5-minute break. It is now, I have no idea what time it is. It is now 10:06. Come back on the record at 10:10, 4 minutes from now. Thank you. All right, we're back on the record. It is 10:12 a.m. Let's have the 4 Tumblr witnesses come down to the witness stand and turn on the microphone. Yes, Ms.
We have one more procedural matter
Oh,
that we
another
wanted to,
procedural.
yes.
Go right ahead.
We would like to move for a directed verdict based on the evidence that's been admitted into the record at this point.
All right. And Machine, you know what they're talking about, right? A directed verdict?
Yes,
Okay.
I won't use any adjectives. But when am I going to do the opening statement?
Well, I'm just asking you, do you know what it means? I know that you're not a trial attorney. Do you know what a directed verdict is?
Yes.
Okay, good. Ms. McLean?
Yes, thank you. And this shouldn't come as a surprise because it was addressed in our pre-hearing statement, this topic. But Marathon moves for a decision on the evidence as it's been admitted so far, based on the fact that working interest control is the controlling factor in awarding operations in a competing development case. And I'd say to order R10731B for that. And the commission has defined working interest control as not simply working interest ownership, but also interests that support a particular operator. And in Longfellow Energy, order number R21834, the division found that the exact criteria for what triggers this is not exactly clear, but when there's only a 7 or 12% interest in ownership, that's when it's not clear. However, in Matador production, they found that there was a clear difference between competing parties when Matador had 62.5% working interest control and Flat Creek had 37.5% working interest. Similarly, in a COG case, it was 96% and 39%, and in a Mewbourne Oil order R14518, it was 74% to 24%. Here, there's a 31% difference in ownership interest. No party has disagreed. Tumblr has agreed with what Marathon has presented. They are coming with less than 9% interest ownership. People don't go to regular compulsory pooling cases with that percentage of ownership. Here, there is a clear difference. That is the overriding consideration before the division, and we believe that Marathon should be awarded operatorship of these spacing units.
So to make sure I understand what you're saying is because of the difference in working interest ownership, we shouldn't even hear this case.
That's correct.
All right. Ms. Shaheen?
Thank you. Marathon misconstrues the orders completely. There are 7 factors, which I can identify if you like.
I know what they are.
And,
Thank you.
and only one of those relates to working interest control. And in fact, that is one of the lesser factors that is considered. In our order number R-10731-B, it expressly states that OCD's first task is to determine which development plan, quote, will most efficiently develop the subject acreage, prevent waste, and protect correlative rights. Only if there are no significant differences between the development plans would OCD look to other facts, and in particular, working interest control. Here we have 4 witnesses who are going to testify about the differences in the development plans. And in addition, they'll be testifying extensively about the good faith communications, or lack of good faith, I should say, with respect to Marathon. So those are just a couple of the factors. The most important consideration in awarding operations to competing interest owners is geologic evidence as it relates to well location and recovery of oil and gas and associated risk. This is the same order. We have extensive testimony to present on that front as well. And again, the good faith factor is another one that we'll be presenting evidence on. Also, whether the operators who can act most prudently. So anyway, there are a number of factors that we will be presenting evidence on, including engineering, which I will note for the record. Marathon has provided no evidence, no engineering evidence in support of its development plan. So with that, I believe the motion for directed verdict should be denied.
So, what I'm understanding from you, Ms. Shaheen, is that the division takes a more holistic approach to granting a compulsory pooling application, that that ownership is one factor, but it could be outweighed by the other factors.
That is correct.
All right. Let me take a few minutes and talk to Mr. McLean.
Mr. McClure.
What exactly what I meant. I'm glad you knew what I meant. Let me take a few minutes, talk to Mr. McClure offline, and I'll come back. I'll take 5 minutes. Thank you.
Thank you.
It's 10:24 a.m. I've had an opportunity to confer with the technical examiner. This is a legal question, so it falls mostly on my shoulders to make a decision here about this. Typically, directed verdicts come at the close of the state's case. Of course, this is not a criminal trial, it's an administrative hearing, so I'm going to convert the directed verdict motion into a motion to dismiss, basically, or a motion for involuntary dismissal. I think that's more applicable to the administrative forum. The question that a motion to dismiss raises, since there is no jury here, since the technical team and myself are the arbiters of the evidence, is there no scenario that Tumblr can prevail? That's really what the motion to dismiss is saying, is that Tumblr cannot meet its burden of persuasion, in this case, through its burden of proof. But its burden of persuasion ultimately is what does not shift. The burden of persuasion is that Tumblr seeks to have the division approve its applications. And from my understanding of the orders that the commission has and that have been cited today and that have been handed down over the years, is that there are 7 factors to consider in granting a compulsory pooling order. And from my research, I have not seen where one factor so overwhelms the other factors that the other 6 factors cannot weigh in favor and ultimately win the day. So because of that, and because we haven't heard all of the evidence, so I'm going to deny the motion to dismiss. So let's get your witnesses up to the podium, please, and get them sworn in and get them qualified. And this might take some time. The podium's over here, gentlemen, where the microphone is. Will you turn it on by pressing, I think, the right button so that it lights up green? There we go. Thank you. Okay, so as a group, I'm going to swear you in as a group, and then we'll go through one at a time, okay? So would you all raise your right hands, please? Perfect. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Thank you. Since you're closest, would you state and spell your name into the microphone? Sure.
Nicholas Weeks, Nicholas Weeks.
And Mr. Weeks, you are, what is your job title?
I am a vice president at Tumblr Operating Partners and a senior vice president of legal, title, and regulatory for Stronghold Investment Management.
Okay. Have you been qualified as a petroleum landman before this division yet?
Yes, sir.
Very good. Excellent. So, Mr. Weeks, please have a seat.
Thank you.
Okay. Okay. What is your name?
Dylan Collins,
Collins.
DYLANCOLLINS.
Okay. And you're seeking to be recognized as an expert before this division in what field?
Geology and subsurface development.
Geology and would geology be?
That's fine. Yes.
Okay, very good. All right. So why don't you sit down there for a moment? And let's go through, actually, you two gentlemen, I don't know how long this is going to take. Usually this is a simple deal, but if we have a party challenging the qualifications of an expert, it could take a little longer. Have a seat somewhere where you can come back up in just a moment. Yes. Thank you. Okay, Mr. Collins, what I'd like to hear from you, and since there might be a challenge, please be somewhat detailed.
Sure.
Into your education. Let's start with your education. What degrees have you obtained?
Yes. So in the back half of my 10 years in the Marine Corps, I earned a degree in engineering geology from San Diego State University. I graduated summa cum laude and #1 in my class. After I was honorably discharged from the Marine Corps, I attended the University of Texas at Dallas. I earned a Master's of Science in Paleomagnetics and Structural Geology, or more generally, Geosciences and Geophysics.
And what years were those?
So I graduated from San Diego State University in 2009. I graduated from the University of Texas at Dallas at 2013.
Okay, perfect. Okay, and what work experience do you have that goes toward petroleum geology?
So just before I graduated from the University of Texas at Dallas, I was hired by Pioneer Natural Resources. I worked directly in development, subsurface development and planning. So I was feeding, or I was filling out rig lines of development for Pioneer's rig schedule for large areas of development in the Permian Basin. I've worked regional geology, done full basin mapping. I've done seismic interpretation, geocellular modeling, among other things.
What years, what time period are we talking about?
So 2012 to 2018.
Okay.
I was the beneficiary of Pioneer's very, very extensive mandate to do science and research and figure out how we develop shale. So it was very, very active, very, very stimulating time scientifically, and I learned a lot.
And what was your title at Pioneering?
I was a geologist, a senior geologist. We've gone through a couple of ranks of geology.
Okay, and then in 2018 you left Pioneer?
2018 I left Pioneer. I came to work for Stronghold Investment Management. I was a senior geologist there. I worked on all of Stronghold's operational business ventures and non-operational business ventures across the lower 48 doing geology. In 2020, I was promoted to director, and so I oversaw all subsurface matters, engineering, operations, and geology. And in 2022, I was appointed to lead one of our operational businesses as the chief executive officer.
Stronghold is related to Tumbler?
Stronghold is the parent company for multiple operational companies and non-operational companies. Tumbler is one of them. Yukon's another one of them. I still carry both roles at Stronghold, Tumbler, or 3 roles: Stronghold, Tumbler, and Yukon.
Okay. Ms. Hardy, is there a challenge to this gentleman's expertise in geology?
Not in geology.
Perfect. Okay, that's all I was going to qualify him as an expert in, is geology.
Understood.
Okay, very good. So Mr. Collins, you are hereby recognized as an expert in geology. That's what I've heard, and that's what we're extending today. So when you testify, if you testify within that expertise, then there's that. If you go outside that expertise, that's where it becomes a little bit different. Okay? All right. So thank you, Mr. Collins. Is it Barker?
Baker.
Baker, thank you.
Yes, sir.
Where the R came from. Okay, Mr. Baker, please have a seat.
Thank you.
What field of expertise do you seek to be qualified in?
Petroleum engineering, operations and facilities, sir.
So does petroleum, petroleum engineering, does that, is that like an umbrella for other things?
Yes, sir.
What?
I'm not going to be speaking on planning and development or reservoir engineering. I'll be specifically speaking to operations, the management of operations of oil and gas, and facilities as well.
So operations and facilities.
Yes, sir.
Okay, so you heard what I asked, Mr. Collins. Just give me a rundown of the education and the work experience.
Yes, sir. So after getting out of the Coast Guard, 7 years, I attended Colorado School of Mines. I earned a Master's of Science and Bachelor of Science in Petroleum Engineering. I left Colorado School of Mines in 2017 and took a job with Matador Resources.
Who?
Matador Resources.
Thank you.
Yes, sir. While at Matador, from 2017 to late 2023, I drilled, completed, and participated in operations in the field and in the office, several hundred wells in Lee County, New Mexico, and Eddy County, New Mexico. Eventually was promoted to vice president, asset manager, where I oversaw development in a high level, as far as, well placements, pad placements, facility placements, marketing agreements and things like that. Once I left Matador in 2023, I eventually took a position with Stronghold or Yukon and Tumblr, which is a subsidiary of Stronghold, as we've just discussed, as a vice president of operations, where I manage all operations, production, completions, drilling, and the construction of facilities. And that's my experience. And I didn't mention just recently, and it's not on my resume, I also provided expert testimony, or I served as an expert for the city of Carlsbad for projects that are being drilled into the city limits over the summer.
Ms. Hardy, any challenge to this expertise?
No, not with respect to petroleum engineering and facilities, which is
And
what he talks about.
operations.
And operations, correct.
Okay, perfect. So, Mr. Baker, thank you. This division recognizes you in the field of petroleum engineering, specifically operations and facilities. Thank you very much. And now, Mr. Villarreal. You might take a little longer. I anticipate you're going to need it. All right. So I remind you, you're still under oath. What field of expertise do you seek to be qualified?
Petroleum engineering, planning and development.
Planning and development.
Yeah, and with respect, so planning and development, so reservoir engineering as well.
And reservoir engineering. How does reservoir engineering interact with petroleum engineering?
It's a subset of petroleum engineering, yes.
Okay, all right. Okay, very good. So why don't you go through what you've heard the other gentleman talking about?
Education and then
please.
experience. Okay. So earned my undergraduate in civil engineering from United States Military Academy at West Point. Had to do 5 years as an infantry officer from Georgia, Washington, Afghanistan. Got out of the Army in 2014, enrolled at Texas A&M, started a Master of Science in Petroleum Engineering. My thesis was measuring source rock overpressure in the Delaware Basin and its relation to carriage and maturity. After my first year at A&M, went to Matador and began working at Matador. Finished my degree there in 2016 while working full time. For education-wise, graduated about 2 years later, earned my professional engineering license in petroleum, state of Texas. Then went on about a year or two after, started a master of business administration from Rice University. That was on the weekends. That was 2019 to 2021. During that time, or I guess also just prior to that, had a petroleum land management certificate from Midland College as well. And that is the education.
Okay. Experience?
So work experience. So following the Army, started at Matador, started doing petrophysics and then the field operations rotation. That was approximately 2 years, then moved in to the recompletions team lead. So that was looking at some of the legacy wellbores, managing a team there. That was evaluating the reservoirs and looking for behind pipe potential. Then, assessing the impacts of, the regulatory and the lease side, and if we could move up hole, and then planning and executing the operations to go do the recompletions. Then moved on to manage the South Texas, North Louisiana, and all of their non-operated assets. Executed a drilling program in South Texas. That was their first time going back to South Texas to drill wells in a handful of years. Then finished my last about 2.5, 3 years while I was at Matador as the West Texas asset manager. So the vice president over West Texas. That was overseeing all of the planning, all of the development, and all of the operations within West Texas. So planning the drill schedule, managing the P&L within the business unit, all the land trades, all the operations, the marketing, anything that's going on in the West Texas assets. And then,
And now with Stronghold?
no. So I left Matador. Then I joined Bain and Company.
Who?
Bain and Company. They're a consulting firm. They're peers with Boston Consulting Group and McKinsey. So worked in their energy and natural resources group, as well as their private equity group, but primary focus was energy and natural resources, E&R. Worked with one of the a major oil company there based in Houston, looking, redoing their capital allocation decisions, their operation models, looking at their OPEX spend and how to reduce OPEX. Primary focus for these initiatives was in their Permian Basin business unit, as well as in the South American unit. Then also spent time looking within their midstream, and then same focus there, specifically op models, how to increase their return on capital employed, and capital allocations. Then I left there beginning of 2024 and started with Stronghold in beginning of 2025. At Stronghold, I'm Executive Vice President of Investments and Operations. So can I grab water real quick? So at Stronghold, manage again all of their investments, operations, oversee all of the evaluations, technical modeling of all their oil and gas investments, all the offers that go out, manage all the valuations of all of the assets, as well as managing just the corporate operations. So from the land teams, the investment teams, HR, IT, our India office, and then also a vice president of Tumblr as well.
Okay,
and that is me.
Ms. Hardy.
I do not object to Mr. Villarreal being qualified as an expert in petroleum engineering.
Mm-hmm. Great. Mr. Villarreal, this division recognizes you as an expert in petroleum engineering. And also, I did hear evidence of, I wrote it down and I can't read my writing, reservoir engineering as well.
Yes.
Okay. Ms. Hardy, did you challenge reservoir engineering?
I do not.
Okay, very good. So those are the two areas of expertise. I know one's under the other, as you said, but still, I want to be clear about it.
Okay.
All right. Now,
Mr. Examiner,
yes.
we also want to make sure that his qualification as a petroleum engineer and reservoir engineering includes planning and development of oil and gas assets and proposals, that kind of thing.
Definitely. Definitely. I've heard enough evidence to show that. Okay, Mr. Villarreal, why don't you take a seat? I don't know who Ms. Shaheen is going to call first.
Mr. Weeks will be our first witness, and I do have notebooks for folks. Might be helpful, especially for the witness. Sure. And I have one for you. And
great.
Mr. McClure, although he may be in Albuquerque.
Mr. McClure is actually in Hobbs. I'll take one of the notebooks. Thank you. Ms. Hardy, do you have a notebook? I don't know if you want one, but she's giving me something and you might want to know what she's giving me.
Sure. Okay.
Does this notebook also have, Ms. Shaheen, your rebuttal exhibits that are not entered? That's okay. No, I'd rather not have those. Sort of what I was getting at. It's not been entered, so I really don't want to see that yet until we get there. But I have a list of what's not been entered here, so thank you. I appreciate it. All right, now Okay, Mr. Weeks, I remind you that you're under oath and the microphone is on, so please speak clearly into it. Ms. Shaheen, go right ahead. Now, did you want to do a short opening?
I can if you like. I got some of my short opening in response to the motion for directed verdict.
Right. Why don't you take a minute and just explain to us why we should approve your applications?
Okay. Okay, we discussed the 7 factors before. We believe that consideration of those factors reveals that Tumblr's applications are superior and should be approved, as will be established today at hearing. Tumblr's disciplined plan and proven team ensure responsible operations, while Marathon's lack of preparedness and corporate instability threaten development. We'll present testimony establishing that operations are led by a team of experienced engineers, geologists, and land professionals with a strong track record of safely and efficiently developing wells in the Delaware Basin. Tumblr is actively pushing for timely development of the acreage, and its cost estimates are grounded in current vendor pricing, consistent with peer operators, ensuring that its plan is both reliable and economically sound. In contrast, Marathon will be shown to have submitted proposals that reflect a lack of preparedness, including repeated AFE revisions, errors in well designs, and communications revealing no firm commitment to drill. Testimony will further demonstrate that Marathon has characterized these wells as discretionary, with no development planned until at least 2027. Corporate restructuring and significant layoffs compound these concerns, showing that Marathon's capital allocation and corporate priorities will continue to outweigh its obligation to protect correlative rights if its applications are approved. Third, Marathon's underspaced Wolfcamp A and failure to co-develop the Bone Spring will result in preventable waste. Both parties seek to develop the Bone Spring and the Wolfcamp formations. The primary difference in the competing development plans is the density and scope of the wells proposed. Tumblr will present evidence showing that efficient recovery requires co-developing the Bone Spring and Wolfcamp intervals at proper spacing to avoid interference, such as parent-child relationships, and maximize reserves. Tumblr will also present studies and expert analysis demonstrating that Marathon's plan, which relies on ultra-wide spacing in the Wolfcamp A by bypassing the third Bone Spring sand, effectively abandoning additional productive benches, leaving oil in the ground. These studies show that Marathon's proposed approach leaves behind millions of barrels of oil equivalent that could otherwise be recovered through proper co-development, thereby causing waste. Finally, Tumblr engaged in repeated discussions while Marathon refused to substantively negotiate. Tumblr will present testimony showing that it consistently sought to engage Marathon in meaningful discussions to advance development of the acreage. These efforts included outreach for meetings, proposals for joint operations, and attempts to find creative paths forward. Most recently, Tumblr's representatives flew down to Midland to meet directly with Marathon without success. Marathon has refused to substantively engage in negotiations. Testimony will demonstrate that Marathon declined meeting invitations, rejected proposals without counteroffers, and ultimately showed no genuine intent to collaborate. In short, Tumblr clearly outperforms Marathon on each factor relevant to considering the competing development proposals. Tumblr's applications should therefore be approved and Marathon's applications denied.
Thank you, Machine. Are you ready to begin?
If I may, I have a copy of Marathon's exhibits.
Oh.
Yeah.
Mr. Weeks, would you show that book to Miss Hardy before you put it behind the I just want her to know what you have. And is the other book still there? It is. Ms. Shaheen, could you take the other, is the other book
He
important
might
to have?
need it
He
to
might need
rebut.
Thank you. Mr. Weeks, if you look at an exhibit to refresh your memory or to, whatever you want to do, please let us know what you're doing.
Yes, sir. I will do my best.
Thank you. Ms. Shaheen?
Thank you. Mr. Weeks, you prepared the land exhibits for Tumblr, is that right?
Yes, ma'am.
Should we walk through those quickly to summarize for the hearing examiners? And I can, if it'd be helpful, I can share my screen. Or would
If
you
we
prefer-
need to, if we're talking about a specific one, then by all means share your screen. But otherwise, we all have these great books in front of us. We don't necessarily need to have it unless your witness does.
Well, he has it, and
Right.
I'll just need to get my notebook
Okay.
here. And perhaps I should address the objection to Mr. Weeks'
I would think so.
statement first off. My understanding from the motion from the objections is that their objection goes to the fact that we filed amended exhibits a couple of days after the deadline for filing exhibits. The only difference in Mr. Weeks' exhibits was we added a plat for the Wolf Camp non-standard spacing unit, which indicates the surrounding offset operators. That plat is essentially the same as, it provides the same information that Conoco's similar plat provides, Marathon's similar plat provides in its exhibits that were filed. So that is the only change to Mr. Weeks' statement, is that he refers to Exhibit A6, which is the plat for the proposed non-standard spacing unit. There are no other changes. I believe there may be one typo, and Mr. Weeks will correct me if I'm wrong there. If
So,
there
Ms.
was a typo.
Shaheen, I have an objection to 4 of Mr. Weeks' exhibits. There's A, A1, A7, and A8, and A8. Now, what I would recommend both parties doing is when you have your witness on the witness stand, have them adopt their written testimony and exhibits under oath, make any corrections necessary, and then deal with the objections, if any, at that time, one at a time. Because I'm not sure which exhibit you're even talking about right now. So let's go through the steps.
Okay.
Go right ahead.
Mr. Weeks, do you adopt your statement in Exhibit A as your testimony here today?
I do.
And do you have any, and that being the amended Exhibit A, do you have any corrections to that amended Exhibit A?
Not that I can recall at this moment.
And is it correct that the only difference between the original Exhibit A filed on Wednesday morning and the amended Exhibit A filed on Friday, the only difference is the addition of paragraph 19, which states Exhibit A6 is a plat of the proposed non-standard proration unit showing the affected parties who received notice. Is that the only change to your Exhibit A, your statement?
I believe that is correct.
Should I have him summarize his testimony in the statement
Not yet,
now?
because A is not admitted into evidence right now, so I don't think it's
Okay.
proper to summarize it yet.
Okay.
Let's go to Ms. Hardy. Ms. Hardy, you challenged Exhibit A.
Yes.
Very good. So here's your witness. Why don't you voir dire him? So just to be clear, can you state what is the objection? What specifically is the objection to, since I have it in front of me now, Exhibit A?
Okay, so there are a couple. Ms. Shaheen reminded me, We had objected to Tumblr's amended exhibits that they filed late on Friday. And that amendment included the plat that she is referencing of the notice to offsets interest owners for the non-standard spacing unit. And we objected to the amended exhibits and that exhibit because it just wasn't timely. It was due to be filed by Wednesday at 9 a.m. And it was filed Friday night. So yes, ConocoPhillips Marathon filed the same exhibit, but we filed ours timely. So there was no reason given for the late filing. And so we objected to the amended exhibits on that basis. And then we have a substantive objection to the paragraph of Mr. Weeks' affidavit where he's speculating about whether ConocoPhillips will actually drill these wells.
Okay, so what part of the, so I don't have the original Exhibit A in front of me. So Ms. Shaheen, specifically what paragraph number and where was this exhibit revised? Just A now.
Paragraph 19
19
was added.
Hold on. Let me get there. And Ms. Hardy, if you think differently, please let me know. Okay, so we have paragraph 19 was added. Go ahead. Go ahead.
That's the only difference.
Ms. Hardy, do you agree?
That seems to be correct.
Okay, so exhibit and paragraph 19 says exhibit A6 is a plat of the proposed non-standard unit showing the affected parties who received notice. And why did you add that?
To support our request for the non-standard proration unit for the Wolfcamp wells.
Are those normally done administratively?
The non-standard, yes, approval of the non-standard proration unit is usually done administratively. And if we did get forced pooling orders, we may move administratively, or we may ask that the division in this particular proceeding approve that non-standard spacing unit. We did ask for that in our Wolfcamp application for both approval of the non-standard spacing unit and for compulsory pooling.
So what's the basis of the objection to include exhibit A6?
Was not timely filed in accordance with the pre-hearing order.
Okay, and your response, Ms. Shaheen?
My response is that amended exhibits are routinely filed at the division. That I think it's to help to assist the division in getting the information that is necessary to consider what is before the division. I don't know that I recall anyone ever objecting to amended exhibits, particularly when it's simply a one exhibit, non-controversial exhibit that that was added. I also note that that Marathon, Ms. Hardy, filed their rebuttal exhibits, their so-called rebuttal exhibits, which actually should have been provided in their case in chief by 9 a.m. on last Wednesday morning. Those exhibits, if those exhibits are to be allowed, this one certainly should be allowed because those are substantive exhibits, which we have not really had the opportunity to fully comprehend. There's been no surprise to Marathon here.
Okay. All right. So the objection specifically is not timely. That's the objection here, is that this paragraph 19, which is the only part that's objected to.
No, we objected to the paragraph where Mr. Weeks is talking about speculating on.
What paragraph number is it?
Well, the paragraphs have changed because this was added. So 28 in this amended version.
So 28. So you're objecting to two paragraphs, 19 and 28. Is that correct?
That's correct.
All right. So now let's just deal with 19, the objection here. The objection is timeliness. Now, I haven't heard, I understand that you've never heard before of an objection, but there is one now to the timeliness of this modification of the, that this should have been timely filed. The paragraph 19 should be timely filed along with exhibit A6. There's an objection. I haven't heard a legal response that allows me to override the rules here
The response is there's no surprise to Marathon. There's no prejudice to Marathon with the addition of paragraph 19 and the plat that reflects the same information that is reflected in Marathon's exhibits.
Ms. Hardy?
The pre-hearing order is clear that exhibits were due to be filed by last Wednesday at 9 a.m. Direct exhibits. Or that a motion would be filed. I think if you're,
No, I'm not. I
Yeah.
have everything I need.
I understand.
Thank you. I'm just thinking about Ms. typically one would argue prejudice in a situation like this. So I hear your argument. But it is in direct violation of the pre-hearing order, and I do expect the parties to comply. So I'm going to sustain the objection on paragraph 19. When you do revise, and I'm sure there's going to be revisions to these exhibits as we go through these this hearing. So please remove paragraph 19 and exhibit A6 from your final packet that you submit. Okay, now let's go on to number 28. What is the objection to 28?
The objection to 28 is that Mr. Weeks is speculating about Marathon's financial thresholds for drilling wells. He's talking about their capital guidance does not appear to support near-term or midterm development of these wells. And I think
What
that's,
sentence are you quoting?
so if you look at it's at the bottom of page 9.
This pattern
Yes, that's part of it. Yes.
and
A lack
Marathon's
of
capital guidance?
Yes.
Let's get some testimony on this. Ms. Shaheen?
So if I understand correctly, Ms. Hardy is objecting to the entirety of paragraph 28. And so I believe that.
I think the objection is speculation. So why don't you ask your witness some questions to provide some foundation for paragraph 28, and then we'll have Ms. Hardy do the same on cross, and then we'll make a decision on 28.
Well, I think that paragraph 28 is supported by exhibit A5, which is 70 entries of communications between Tumblr and Marathon.
Oh, okay, thank you for that assertion, but let's get the witness who's under oath to testify to the foundation of 28. It is his expert testimony, which he's adopted under oath, and there's no corrections to it as far as I understand. So why don't you ask about 28?
Okay. Mr. Weeks, can you summarize the substance of your testimony in paragraph 28 and identify what you've considered in forming your opinion in this regard?
Certainly. Pardon me, as I flip to
It's page
9.
3 of 328.
Perfect. Thank you. The summary of paragraph 28 relates to a series of communications that have occurred with Marathon over the course of more than 18 months regarding the plans for development of the acreage at issue in this case. Consistently, Marathon has established a pattern of not providing a specific drill by date for the wells that they have proposed in this case. They have referred to, in their drill schedule, they've indicated that those wells are discretionary, which shows that they are not required to be drilled. The communication also indicates that they continue to move the wells back on the schedule throughout the period of time from 2024 through to today. We have seen that consistent progress, and when asked when we asked Marathon about why these wells are having a difficult time finding a place on the drill schedule, Marathon has an email that I believe I refer to in my exhibit A5, where on March 18th, 2025, sorry, March 19th of 2025, in response to an email from March 18th, Marathon indicated that the reason that the wells weren't on the rig schedule did not have anything to do with rig availability. Following up on March 28th, Marathon, we asked, why is Marathon unwilling to pursue the project, getting permits in hand and pooling orders that are set to expire in less than 2 months? And with Tumblr reiterating that we are willing to discuss any avenue to see these lands get developed, Marathon indicated that the reason that the wells are not on the drill schedule is, quote, we have such a large portfolio of New Mexico inventory competing for capital, and then why COP is not developing, inventory competing for capital is why COP is not developing this project this year. Capital guidance and capital focus are the cause of the delays. And based on those communications with Marathon and the lack of any additional information being proffered, we identified that Marathon's delay is caused by there is a significant concern for Marathon that Marathon will continue to delay the development of this project.
And Mr. Examiner, if I may, just note for the record, I know we're the discretionary application of the rules of evidence, but Rule 11-703 specifically allows an expert to base an opinion on facts or data that the expert has been made aware of or personally observed, including email communications. And the communications need not be admitted or admissible if experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion.
Thank you, Ms. Sheen. And I'm going to go to you in a moment, Ms. Hardy. I have a question for the witness. The table here talks about communications between Tumblr. I think this is at the top of it says here, communications between Tumblr operating partners and David 36-24 working interest owners. Question for you. Are you one of the Tumblr operating partners that was having this communication? I had communications, but later on in the life of the project. So whose communications are these relying on?
These communications are largely from emails between Chris Villarreal and various land personnel at Marathon, or Kristen Wilpitz, who is a landman for Tumblr, and other various personnel at Marathon.
Okay. And how did you obtain these communications?
I reviewed the emails that had been sent. We keep a log of communications.
Okay. Ms. Hardy?
Mr. Examiner, I still object.
Do you want to ask the witness any questions?
Sure. Hello, Mr. Weeks.
Hello.
You weren't a party to these communications yourself, were you?
I was not a party to the communications themselves.
Okay. And you've never worked for, well, you don't work for ConocoPhillips or Marathon, correct?
I do not.
And you don't have any information regarding their capital project guidelines, do you?
The only information I have regarding their capital project guidelines is what has been communicated to me either by Conoco's landmen or communicated to Tumblr through Conoco's landmen or Marathon's landmen or other statements that have been made in public.
And you don't have any knowledge, or do you have any knowledge regarding what it means to have a discretionary project as defined by Marathon?
On September 3rd of 2025, I personally had a discussion with land personnel from Marathon. That was Sean Miller. And in that phone call, Sean identified the wells as discretionary, as in not needing to be drilled at this time, and that his land department had to effectively lobby his asset team to add the wells to the drill schedule.
Okay, and I understand that that's hearsay, but my question was, you don't have any understanding, do you, of what it means to have a discretionary project as defined by Marathon?
Only what Sean Miller communicated to me in that phone call.
Okay, and I'm looking at your table here of communications that you're relying on in support of this testimony, and that is it. It's your exhibit page. It's A8, I believe, right? It's hard for me. I can't see it. It's cut off.
It's A5.
A5. Okay, and Marathon was acquired by ConocoPhillips in November of 2024. Is that your understanding?
No, that's not my understanding. My understanding is that Marathon merged into ConocoPhillips as a wholly owned subsidiary, with personnel continuing on into ConocoPhillips, and that Marathon continues to exist today.
You're not aware that there was an acquisition of Marathon by ConocoPhillips?
I'm aware that there was a merger.
Okay, that's your understanding.
That is correct.
Okay. And the communications included in your log here, almost, let's see, up to November of 2024, are prior to that transaction, correct? Whatever you want to call it.
Yes, those communications occurred prior to the consummation of the merger.
Okay, I maintain my objection
Okay.
to his paragraph 28 being hearsay.
Okay, I find enough basis for this statement, for this expert statement, based on the testimony, based on the exhibit. I don't find that Mr. Weeks not being in the chain of emails as they were originally sent is a problem. I think he reviewed emails. There's no allegation that the emails have been changed in any way, that they're not authentic. He also had, in-person discussions with personnel recently. So I find that this paragraph 28 in the administrative forum is relevant and reliable enough to consider. Now, whatever weight the division wants to put on this statement is the choice of the division. And your objection is noted, but I overrule that objection as to paragraph 28. So that may remain. Now, for the rest of for the rest of exhibit A, because we do have other exhibits under Mr. Weeks' submission that we need to deal with, but for this exhibit A, it's admitted into evidence, except for paragraph 19, which has to be removed. And that exhibit A6 has to be removed from the consideration unless a door is opened down the line later. But for now, that's how it stands. Is there any other summation that you want Mr. Weeks to give to his expert? I mean, do you want him to state what his expert opinion is at this point?
It would be helpful, Mr. Weeks, could you highlight or point out the highlights of your testimony in Exhibit A?
Yes.
I would, in particular, ask that you talk about your statement in paragraph 27 first.
Certainly.
And that's page 53 of 328.
Thank you. Appreciate it. Believe what I would highlight for the majority of my statement is that Marathon has had these assets for quite a few years. They have made some progress towards development of this project. However, they have failed to execute on a development plan and have consistently pushed development timelines down the road and have yet to provide a definitive date on when they intended to develop the projects. Tumblr acquired the asset in 2 years after Marathon had acquired its initial interest in the asset. And Marathon or Tumblr was happy to own the asset at those times when Marathon was showing progress in developing the project. However, it has become clear based on their communications and based on their actions that what has become less clear is their development timeline. And so Marathon, in the interest of protecting correlative rights and preventing waste, Tumblr, in the interest of protecting correlative rights and preventing waste, took it upon itself after communications with Marathon to seek to have these assets developed for the benefit of all of the stakeholders, and not just and no longer to be prevented from to keep this acreage from not being developed.
Is it fair to say that Tumblr filed its applications because Marathon sat on its hands since it acquired its interest, and that Tumblr had originally elected to participate in Marathon's wells, but Marathon allowed its pooling orders to expire? Isn't that right?
I object to the question. Ms. Shaheen is testifying and it's leading of a direct witness.
Sustained. Would you rephrase your question, please?
Yes. Can you describe Tumblr's communications with Marathon when it first proposed these wells?
Certainly. Tumblr initiated conversations with Marathon to identify methods to work together with Marathon to see that the wells get developed and that the development is timely, offering a number of different collaborative opportunities to see them developed, including various trades or divestitures or acquisitions to incentivize the development of these. Marathon proposed the wells under its prior pooling order to Tumblr, and Tumblr elected to participate in those wells and attempted to negotiate a joint operating agreement with Marathon. But in January, it became fairly clear that Marathon was no longer seeking to develop these wells in a time frame that would protect the correlative rights and prevent waste. And then when the pooling orders were, it was apparent that Marathon was going to allow the pooling orders to expire. Tumblr proposed its David wells.
So is it your understanding that the only reason Marathon proposed the applications that are before the division now are because Tumblr proposed to develop that acreage?
I object to the question. It calls for speculation as to why Marathon filed its applications.
I'm just asking for Mr. Weeks' understanding.
Hold on, I haven't ruled on the objection. There is an objection. If you hear an objection, you have to stop. I do think, Ms. Shaheen, so I'm going to grant the objection because I do think, or sustain the objection, because I do think it asks for a conclusion that is beyond this person's knowledge base. I believe that at this point, he'd be stretching the term expert to that. So either rephrase the question or move on to another area, because we have a bunch of exhibits that are not admitted that we need to deal with.
That's true. I think Mr. Weeks can rely on his direct written statement at this point.
So I think we need to deal with Exhibit A1 next.
A1. Yes, I understand.
Well, What is the,
Um,
I'm sorry, I'm sorry to interrupt you. What is the objection to A1? I'm not clear on that.
Exhibit A1 is the C102s.
Yes.
And none of them are signed by the company or by a surveyor.
Okay.
And OCD has required signatures on C102s that are submitted in polling cases.
Pretty clear and straightforward. Machine?
Mr. Weeks, can you tell us why these C102s are not signed?
Certainly, calling your attention to the bottom left corner of the C102s, I believe that there is a certification statement that indicates that a person signing this C102 must own an interest in every quarter section that is sought to be drilled across, or in the absence of that, must have reached voluntary joinder with a party that owns in those quarter sections where the signatory does not own, or failing that, an order must have been issued, pooling order must have been issued in the case. Tumblr does not own a working interest in section 36, and therefore to sign this certification would, well, it would be a lie.
Okay, what about the other conditions? You mentioned 3 or 4 conditions, but you only mentioned one that you don't have.
Oh, as far as the certification statement? Or?
You just went through a list of
Correct.
Yes.
And sorry, yes, sorry,
Yes.
thank you. To conclude that, or to continue that thought, we have not signed an operating, EOG has not signed an operating agreement with either party in this case.
Okay.
And Marathon has not signed Tumblr's operating agreement. EOG and Marathon are the only parties that own working interest in section 36. And as far as, and so we don't currently own, Tumblr doesn't currently own an interest. No party that owns an interest has executed an operating agreement with Tumblr. And we are seeking the pooling order in this case today so that we might execute that certification statement.
Okay, so Ms. Hardy, your objection is that they're not signed. The witness has explained why he's unable to, or why Tumblr's unable to sign them. What's your objection?
My objection is that in compulsory pooling cases, OCD has required operators to sign a certification on draft C102s, even if they're not filed. It's correct that when they're filed, you have to have an interest in every tract to certify them, but that's been OCD's practice. In fact, cases have been continued because C102s weren't signed. So that's been OCD's practice.
Machine.
There's no regulation and no guidance, to my knowledge, that requires signature of a certification when you would be falsely certifying the C102. And if that said, if the division wants us to file signed C102s, we can certainly do that prior to the time you take this case under advisement.
Okay. All right, let me take a few minutes to discuss this with Mr. McClure, see how he wants to proceed. Let's take a 5-minute break and we'll be back on the record. It's 11:22 now. Thank you.
No, I think we can proceed. Thank you.
All right, we're back on the record. We were considering the admission of Exhibit A1 into evidence, and after consulting with Mr. McClure, we agree that it would be a problem for Tumblr to sign these as they stand now, but otherwise, we don't hear that they're not accurate. We don't hear that they're not relevant or reliable. So we're going to admit Exhibit A1 into evidence. So the objection is overruled. Let's go on to A7, which is not in evidence at this time.
That's the
that's
rebuttal
rebuttal.
exhibit, which I haven't looked at yet.
I'm confused. What do you mean you haven't looked? It's your exhibit?
It is,
Oh,
but these were finalized this morning, and I can take a look now. Exhibit A7.
Yeah, we need to be prepared for each witness to be able to deal with their direct and rebuttal. What is the objection to A7? Let's start there.
Well, these exhibits aren't actually labeled.
Do I have a copy, Ms. Shaheen, of A7?
You asked me not to pass them out.
I did, but I need, now at this point, I need to see it. And I want Ms. Hardy to take a quick peek at what you're going to give me so I know that it's what she is expecting it to be. That's fine. That's fine. Because yeah. So Ms. Hardy, first I want to know, is this the exhibit A7 or this packet? Is this what you received? This looks authentic to you. Okay,
yes.
Very good. So A7, let me look at it now that I have a copy. How many pages is Mr. Weeks? How many you prepared A7, didn't you?
That is correct.
How many pages is A7?
One moment as I flip to it.
Okay. Were you handed a copy of this?
Yes, sir, I was.
All right.
Yes, A7 is one page.
Oh, it's one page. So it's just this diagram.
It is.
All right. And Ms. Shaheen, if this does get admitted, please mark it.
We will do that.
Right. As rebuttal A7.
Yes.
Just to be clear. Okay. So what's the objection? I'm sorry, Ms.
Well, I'm trying to figure out, so the exhibits are not labeled.
I know.
So I'm trying to figure out what page, what exhibit A7 is.
Do you want to share this on your screen now so we
Sure.
can all see what you are calling rebuttal A7?
And we'll have Mr. Weeks confirm that.
Yes, of course, office.
Okay.
Okay, that's what I show.
Mr. Weeks, is this exhibit rebuttal exhibit A7?
I don't believe so.
Oh,
dear.
okay.
The rebuttal to Exhibit A7 is titled Rebuttal to MRO Exhibit A39 and 40. Documentation contradicts MRO's assertion of good faith negotiation.
Do we have a page number?
I do. It's page 2.
Page 2 of 20?
Yeah.
I believe it's page 86 of the packet.
86. Thank you. I don't know how you know, but thank you.
Here we go.
Yep.
I don't know how to find page 80.
In your hard copy, it's going to be about 8 pages from the back.
8 pages from the back. Okay.
And these are double-sided pages, of course.
Will you put it on the screen or is it on the screen now? That's on the screen?
This is on the screen now.
Thank you.
This is
So
A7.
this is A7 then?
Correct.
We're gonna have to do a better job at the exhibits. It's too chaotic not to know what to look at. Especially because A7 is, anyway, okay.
We can have them
Yes, of course.
labeled over the lunch break.
Yes, that'd be wonderful.
Okay.
Okay, so let's talk about this document. What is the objection? Now that we know what document we're looking at, what is the objection?
The objection is that it contains hearsay, commentary. It's not complete statement of these communications. It's misleading for that reason.
Okay. Let's have some testimony. You've heard the objection that it's misleading because it's not complete. It's incomplete. These quotations are just, nitpicked, taken out of context, let's say. And that it's also, it contains hearsay, which we all know is admissible at an administrative hearing, depending on the reliability. But I think what Ms. Hardy is getting at, and correct me if I'm wrong, is that this is unreliable the way it's presented here. It's misleading. So go ahead and.
Well, I would say that this is Mr. Weeks' opinion.
Well, go ahead and question your witness.
Oh, you want me to ask?
Oh, yeah, I don't want to hear I just want.
You don't want to hear my legal argument?
No, I know. I want to hear from the witness.
Okay. Mr. Weeks, can you tell the hearing examiners the basis for this Exhibit A7, rebuttal Exhibit A7?
Certainly. In his self-affirmed statement, Mr. Miller indicated that Marathon had made multiple attempts to engage in trade discussions with Tumblr. After reviewing the communications between Tumblr and Marathon, the record of those communications reflects that, in fact, Marathon did not engage in good faith negotiations with Tumblr for finding an alternative to participation in trade negotiations or any other type of means to resolve this without having to go through a forceful hearing. And so I reviewed those summary of communications, and from the emails, which we can produce if necessary, we highlighted specific portions of those emails that are on topic and relevant to the consideration of good faith negotiation. Specifically, in April, Chris Villarreal approached Marathon and indicated that it was interested in talking about trades with Marathon and finding a way to finding a path forward. We indicated we were interested in discussing that and offered to visit Marathon at their office. Sean and Marathon responded and asked if there were any trades that we had that Tumblr had in mind. And then Chris responded back to Sean and Caroline that with a series of categories of positions that we would be interested in making a trade for. And those included categorizations of types of reservoir class, for instance, producing wells or wells that are in near-term development. Alternatively, he offered up a concept of or a preference for certain operators for which Tumblr would be willing to trade into a position and out of the David acreage. And finally, identified specific areas that Tumblr would be interested in making a trade for with Conoco. The response, there was no response for 5 days regarding the potential trade. And the response on the 9th was that from Sean that he understands that the non-op interests would be of interest, but his team and he don't have time to go through our various portfolio to put a trade schedule together for your consideration. In his testimony, in the chronology of Marathon's chronology of contacts, it is characterized as Chris responded naming a few general areas that Tumblr would consider trading for. MRO responded stating that COP would evaluate a trade possibility if Tumblr sent a trade proposal with specifics. Without knowing ConocoPhillips's ownership interest in these areas that we would be interested in, I don't know how we would add specifics. Additionally, Marathon was aware of Tumblr's ownership position in the David acreage. So I'm unclear. It does not appear that there was good faith negotiation on behalf of Marathon as declared in their exhibit, the land exhibit.
And these communications, again, are reflected in the requisite chronology of contacts that is attached to your exhibit, your statement, Exhibit A, attached as Exhibit A5. Isn't that correct?
That is correct.
Ms. Hardy?
Well, Mr. Examiner, these are excerpts that are taken out of context. So it's misleading as an exhibit and I object.
Okay, so there is a rule of completeness, Ms. Shaheen. I don't know if Ms. Hardy, if it benefits her position to admit these emails into evidence, but is that a possibility to?
Absolutely. And we're more than willing to provide the emails as exhibits as well.
So these are emails that you reviewed, but these are emails mostly to Mr. Villarreal, who's raising his hand in the audience. I wonder, and don't we have Mr. Miller as well here? I thought so. Yeah, there's Mr. Miller. So we have both parties who were involved in these, and they can be questioned about their involvement. But I see enough evidence to admit this rebuttal exhibit A7. The division can give it whatever weight it so chooses, especially because we can also hear from Mr. Villarreal and Mr. Miller, who were communicating back and forth. So, Ms. Shaheen, Ms. Hardy, you have that opportunity down the road. But this exhibit is admitted into evidence. Let's go on to A8.
Oh, I did not mean to be sharing this. Sorry.
What I need to know what I'm looking at, though. Where is A8?
Yes, Mr. Weeks, can you direct us to A8?
Certainly. I don't know which page number it is in the packet, but it's titled Rebuttal to MRO Exhibit A, number 44.
44 or 41?
Number 44. MRO's development will not be timely.
Can you describe?
Can you show it on the screen? Or are you showing it? Oh, you are.
Yes.
So, Ms. Shaheen, you handed me a packet of information, but I don't see this in the packet. What page would it be on?
This is about 3 pages from the back.
Perfect. Thank you. I found it now. Thank you. So this is A8. Excellent. Go ahead.
Mr. Weeks, can you explain to the hearing examiner the information contained in rebuttal exhibit A7?
And Mr. Weeks, before you do that, what is the objection to A8? So I know what the basis is.
I'm just looking at it.
Right.
I just received it. I don't understand what it's trying to show. I don't think there's a basis for this sort of speculation on pooling orders, and I don't think it's actually rebutting anything.
Okay.
I think this could have been submitted as a direct exhibit if they wanted to argue about timing and the deadlines under pooling orders.
I understand.
Do you,
So Ms. Shaheen, first of all, let's find out what is this rebutting? Because to be a proper rebuttal exhibit, we need to know what you were surprised by in the original exhibit packet that this is rebutting. So can we start with that?
yes, this is the rebuttal to Marathon Exhibit A, paragraph 44,
Okay.
which is basically Marathon's timeline. Its purported timeline for the development. We're rebutting
Okay.
that statement.
Okay. All right. And now what is it showing? Let's find out from the witness.
Okay.
Yeah.
Mr. Weeks, can you describe to the hearing examiners what this rebuttal exhibit A7 shows?
Certainly. The rebuttal to Marathon's A44, Exhibit A44 shows a timeline of Marathon's, the history of the development of this project by Marathon, and it indicates a series of communications from or statements on Marathon's own pooling exhibits that appear to indicate that where Marathon has stated that its development of the asset will be timely. However, in its timeline provided to the division and provided to Tumblr, it seems to indicate that Marathon does not intend to spud the wells, that's Goliath wells, prior to the potential expiration of a new pooling order being issued, which is contrary to, I believe, the paragraph 20 of the standard pooling order form, which states that I believe all wells must be spud within 1 year of the execution of the pooling order by the, I believe, by the commission. For instance, in its chronology, Marathon has indicated that it's not going to spud these wells, spud its first well until 2027. If the order is issued prior to the end of the year in Q4 of 2025, that new pooling order would expire prior to Marathon spudding its first well, and certainly prior, I would assume, prior to Marathon spudding all of its wells.
Looking for paragraph 44 in Marathon's Exhibit A. Miss Hardy, would you pull that up? So, because what I see here doesn't comport. I haven't seen it before until just now. Can I see paragraph 44 for Mr. Miller? I suspect it is.
Yes.
Thank you. My paragraph 44 is a conclusion paragraph. It doesn't have anything about dates in it, though. But that's not a question, so don't answer yet. Let's just look at paragraph 44 first.
Can I share?
Yes, please.
I'll stop.
Thank you.
Oops.
I think it's page 14, Miss Hardy, but I'm guessing. Is that it?
It is.
So, Ms. Shaheen, I'll let you read this paragraph.
Yes. Did you have a question for me?
I do.
Okay.
My question is, how is this Exhibit A a rebuttal to paragraph 44?
Well, I believe it's because Mr. Miller represents that Marathon's development plan will allow for prudent and timely development of wells in the unit. And what we're illustrating here in this rebuttal exhibit is that it's not timely, because if, hypothetically speaking, Marathon received approval of its application, say they came out in Q1 of 2025. In other testimony, Mr. Miller has stated that they're not going to be developing these wells until 2027. So they're not developing until a hypothetical forced pooling order will have already expired. So clearly their development is not going to be timely. I think that's the summation of what we're trying to say in the rebuttal exhibit A7.
Ms. Hardy?
And I think Ms. Shaheen keyed down on the key term here. It's hypothetical. Mr. Weeks does not know when the division will issue a pooling order in these cases and does not know when it would become final. There could be a de novo hearing. The division typically does take longer to issue orders in contested cases than in other cases. There is no way that Tumblr can say with any degree of reasonable certainty when a pooling order will be issued in this case.
Well,
okay. Thank you, Ms. Hardy. Ms. Shaheen, so that brings up another question in my mind. Which pooling order is this witness referring to when he says that it won't be timely or prudently developed? In other words, it was my understanding that Marathon had a pooling order. I think I brought this up at the beginning of the hearing. Marathon had a pooling order. It got an amendment. That amendment, I think, is gone now, or it's not extended, or whatever it may be. I'm not clear from this exhibit what he's referring to.
you mean the rebuttal exhibit
Yes.
A7?
Yes.
Okay, can I pull it up again?
Yes, of course.
Okay.
Please.
So if the timeline begins over in 2023,
Right.
First indicates when the pre-merger announcement occurred.
And
Then
below it says
that's
pooling orders.
pooling
You
orders,
see?
right? And pooling orders. I need to ask Mr.
Go ahead.
Weeks. Mr.
Please.
Weeks, what is the reference to pooling orders there right below the timeline on 2020?
Certainly. In this timeline, what we are indicating is that Marathon had pooling orders previously issued from 2023. In May of 2024, those pooling orders were extended for a year, and ultimately, Marathon allowed those pooling orders to expire in May of 2025. In August, Marathon files its application for compulsory pooling, which at the end of which I assume a new set of pooling orders will be issued to a party. If those pooling orders are issued in favor of Marathon's development plan, they will have an expiration date. Paragraph 20 of the standard pooling order form states that an operator will commence the drilling of all wells listed under the pooling order prior to the expiration of 1 year. Tumblr's statements in its record indicate that it does not intend to commence development until sometime in 2027 prior to permits expiring. The assumption is made that when those pooling orders are issued, they will be issued sometime in this example in Q4 of 2025. It may not be until Q1 of 2026. We don't know. What we do know is that Marathon will have to drill or commence drilling of 17 wells in order to timely develop the asset under the terms of the pooling order that will be issued in this case, should they be issued in favor of Marathon. And so that second set of pooling orders, that estimated new pooling order, is in reference to any pooling orders that may come out of this contested hearing.
And then you have a quote at the bottom in a box. I don't remember you testifying about that.
I'm sorry, I did not. It is, I believe in Marathon's exhibits A, number 39, Marathon has indicated that it is unreasonable for Tumblr to request that all of the Goliath wells be drilled and completed within 2026. And that comes, so that it is unreasonable to expect that development will occur in 2026.
Okay.
Which would be the time frame covered by the pooling order.
Okay. I've heard enough evidence and testimony and argument about Exhibit A8. I don't find it helpful. I don't find it reliable. I'm not admitting A8 into evidence. So that is excluded. Okay, I believe those are all the exhibits under that come in by this witness, Ms. Shaheen. So
Is that correct, Mr. Weeks?
As far as the rebuttal exhibits, that is correct.
Well, all the exhibits.
Yes, A1 through A5.
Right.
Yes.
Yes. So just to be clear, A2, 3, and 4, and 5 were admitted through stipulation. A and A1 have been admitted over objection. So has A7. So the only exhibit that has not been admitted from this witness, Ms. Shaheen, is number A8.
Okay.
And I believe there's a paragraph in A that needs to be changed. And I believe, I forgot the number, maybe 19. I really don't remember. But anyway, are there any other questions that you want this witness to summarize now that we have all this evidence in? Are there any other summary questions that you want this witness to answer before I turn him over to cross-examination?
I think there's probably additional rebuttal that I haven't gotten to, but
Okay.
if I'm allowed to come back with rebuttal after we've heard Marathon's witnesses, we can cover it then.
As long as Ms. Shaheen, as long as you're able to convince me that there was some surprise that occurred that requires rebuttal, then of course, you have a full and fair opportunity to present your case. So are you ready to turn this witness over for cross-examination?
Let me just follow up on a couple of things.
Okay.
Ms. Shaheen, you're sharing your screen.
Oh, shoot, sorry.
Let me make a statement before I forget. Mr. McClure brings up a very good point. I did not admit A6, which was the exhibit that went to that paragraph 19, or I think it's 19, or is it 9? I don't remember. Okay, so there are actually two exhibits that have not been admitted. It's A6 and A8, and a correction is needed for A. Just want to be very clear.
Yes, thank you.
And Mr. Court Reporter, you're keeping track of that, right? Thank you. Okay, so Ms. Shaheen, you were speaking and I interrupted you.
Yes, Mr. Weeks, we were speaking earlier about why why Marathon filed its applications in this matter. And have you reviewed Mr. Miller's chronology of contacts? And if you could turn to that, I believe it is exhibit. Exhibit A11, page 115 of 243 in Marathon's exhibits.
I'm there.
And looking at the third entry here, it's an email relating to EOG resources. It appears that, does this email relate to Marathon's reasoning for submitting its applications that are at issue before the division now? And if you need a minute to take a look, please, Steve.
Thank you. Yes, in the chronology of contacts, in the email exchanges between Marathon and EOG, it does provide some information regarding the rationale and the timing of proposals sent by both Marathon and EOG.
And what does it say?
It says that Lacey reached out notifying MRO that EOG wants to protect its acreage from Tumblr's proposed development, and it would be sending out counter proposals in the next few days.
And EOG ultimately decided not to file competing proposals. Is that correct?
That is correct. MRO responded, stating that MRO would also like to avoid a contested hearing with EOG and that MRO would consider an offer, but MRO also needs to defend its position and will be sending proposals for the Goliath unit. And it's not on this chronology of contacts. I'm not certain why. I believe it's probably the mailed column. 7/9/2025 is when Marathon mailed its proposals, its Goliath proposals, only after Tumblr had mailed its, and in response to Tumblr's mailing of its David proposals to both Marathon and EOG and the remaining parties.
Turning to paragraph 12 of Mr. Miller's testimony, and this is on page page 10 of 241. Wait a minute. Yes. Paragraph 14.
In the exhibits for case 25542.
Yes, that's the one that I'm looking at, or it's the bone spring application. I think so. 25541, actually. Page 10 of 241.
Okay.
In paragraph 14, Mr. Miller represents that Tumblr has only been an operator in New Mexico since 2025. Do you see that?
I do.
And do you have a testimony that rebuts Mr. Miller's testimony there?
Yes, I'm not certain exactly what Mr. Miller is referring to when he says has only been an operator in New Mexico since 2025. Tumblr, I believe, received its O-grid number from the NMOCD back in 2019 and has been bonded with the state since.
And Mr. Miller also represents that Tumblr has never drilled any wells in New Mexico. Isn't it true that there are employees, staff members, representatives of a Stronghold and that are working on Tumblr matters who have drilled wells in New Mexico?
Yes, that is accurate.
From a land perspective, how does Tumblr's development differ from Marathon's?
Our development includes 14 additional wells that Marathon has not proposed in its development plan. We are proposing wells that will target the Upper Avalon, the Third Bone Spring carbonate or Harkey Mill sand, and the Third Bone Spring sand, and those were included in the proposals that Kristen Wilpitz mailed out to the various parties.
If we turn to, and here I've got to find it again. If we turn to Marathon's tract ownership exhibits, and I believe these are pages 84, 85, pages 83, 84, 85 in the Wolf Camp package. Do you have that handy?
I do.
And do you see their tract ownership here? They have how many tracts are indicated?
They have indicated that there are 2 tracts.
And is that your conclusion as a land expert, that there are only 2 tracts?
No, that's inaccurate. They have identified sections 24 and 25 as being a single tract of common ownership, and that section 36 is a separate single tract of common ownership. The record title available in the county courthouses indicate that there is a difference in overriding royalty interest between sections 24 and 25. Additionally, in section 25, there is a difference in working interest ownership as well. The north half of section 25 has the same owners, but a reduced working interest ownership as the south half of the south half of 25 has 2 additional working interest owners in it that do not own in the north half of section 25. For instance, they have identified Puma Mineral Partners LLC as owning throughout section 25, and that is inaccurate. The assignment into Puma Mineral Partners was limited to the south half of that section.
Have you reviewed the APDs the BLM APDs that Marathon has?
I have reviewed them to a limited extent, yes.
Do you have an opinion on the consistency between the APDs and the C-102s that Marathon has submitted in its exhibits?
Yeah, you would bear with me as I turn towards those C-102s. It appears that Marathon's C-102s are inaccurate. With respect to the size of the number of tracts, or the acreage for the tracts in the south half, I guess technically the lots that make up the south half of the north half of section 36.
Do 5541 matter?
That is correct. Thank you.
To sum up, do you have more testimony about the C-102s?
I would only also point out that there is no surveyor certification on their C-102s either.
And to sum up your testimony, in your expert opinion, as a petroleum land expert, will Tumblr's proposed development best protect correlative rights and prevent waste?
Yes. Tumblr's development plan will prevent waste and protect the correlative rights of the various stakeholders.
And is that one of the reasons because Tumblr's proposes to timely develop this acreage?
Correct. Tumblr intends to, once a pooling order is issued in its favor, Tumblr intends to submit the APD, execute C-102s, submit the APDs necessary to develop the wells, and we are working with a number of contractors, including Permits West, who will help facilitate having those permits approved at a rapid pace.
Thank you, Mr. Weeks. I'll pass the witness with the understanding that if there are surprises in Marathon's testimony of its witnesses, we will be allowed to rebut that testimony.
Thank you, Machine. Ms. Hardy, it is 12:07. I figured you'd want to think about your cross-examination, maybe over lunch. How much time would you like for lunch?
I think if we could come back at 1:15, that would be
1:15.
sufficient.
Machine, how are you on 1:15?
If we could say 1:30 so we could get the rebuttal exhibits properly labeled,
That would be nice. Yes, thank you.
especially because I'm not sure if my assistant's going to be around over the lunch hour.
All right.
That's fine.
This, so this is taking longer than normal, and that's fine. We're here to get the full picture here so we can make an informed decision. Where are the Tumblr witnesses? Were they planning on leaving this afternoon?
They're
Good. So you're covered. So you have a place to stay overnight if necessary? That's what I wanted to know. All right, good. So Ms. Shaheen, this is most likely going to go into 2 days, but that shouldn't be a surprise at this point. And your witnesses, Ms. Hardy?
They are available.
They are available. Thank you. But where are they planning on going back to when this is over?
I believe they will go back to Midland
Oh, Midland. Is that
tomorrow.
accurate? Okay. Are there 2 or 3 people? I see 3 people sitting there that I don't recognize. So
We have
there's
two,
3
we have 2 witnesses
and someone else.
and 1 helper,
And good.
a very critical helper.
Yes, well, that's excellent. Okay, good. So we'll come back. So Ms. Shaheen, I understand that, but I want to try to be timely with this. So I'm going to say we're going to come back at 1:15. You give your assistant instructions. Getting these exhibits properly marked is good, but it's not critical at this moment. I really want to keep this moving to the best of my ability. Okay, so with that said, we'll be back at 1:15 and you're still on the witness stand at 1:15. Thank you very much. We're off the record.